The ad hoc committee established to investigate allegations made by KZN Police Commissioner Nhlanhla Mkhwanazi held public hearings as part of its participation process. They've been hearing from various interested parties, including Accountability Now's Advocate Paul Hoffman, who joins us now for more. Advocate, thank you so much for your time and for joining us this evening. So yesterday when we spoke to the chairperson of the Parliamentary Ad hoc Committee, explained that there were over 200 submissions from the public as well as civil society organizations. How pivotal is the voice of the public in this process?
Good evening, Kakhetlo, and good evening to your viewers on Newzroom Afrika. Yes, I think that the public voice in relation to the work of the ad hoc committee is indeed important. Accountability Now had the honor of being the first of the members of the public who have, in 200 different submissions, interacted with the ad hoc committee in cyberspace or by way of correspondence. But this was a live meeting that went on all day yesterday, and our approach to the work of the committee was to seek to identify the mischief which it is tasked with addressing from the point of view of the legislature. We all know that the Nhlanhla Commission is looking at the same issues from the point of view of the executive branch of government, in other words, from the point of view of the National Cabinet and the Minister of Justice and Minister of Police, or Acting Minister of Police, I should say.
And
so the mischief that we identify.
Right.
Yes?
Yes, no, continue, finish your thought, Advocate.
The mischief that we identified is that rampant, serious corruption with impunity and organized crime are the problems that need to be addressed. And the thrust of the submission made by Accountability Now was that the highest court in the land has considered these issues itself as long ago as 2011. And in a joint majority judgment in the case that is now called Glenister 2, the court ruled that our law demands that a body outside executive control is to deal with corruption effectively is what South Africa needs. Unfortunately, that body has never seen the light of day. So it was my duty to draw the attention of the committee to this oversight and to encourage the committee to do the necessary remedial legislative work in order to address the levels of falling around and dysfunction and lack of resources and lack of skills, lack of security of tenure of office that mark the current entities involved in the criminal justice administration's efforts to deal with corruption.
Right. So, Advocate, this body that you speak of is that Chapter 9 institution that you made mention then in Parliament, that Anti-Corruption Commission. Why do you think it's taken so long if, as far as you mentioned, the High Court had already considered this, that it's taken so much time for it to even be considered?
Yes, the Constitutional Court has made a binding ruling, but there has not been the political will to implement the ruling properly. The ruling was misinterpreted by government, especially by Parliament, when it was debating what to do, because it was told by the court that it needed to pass remedial legislation to address the shortcomings in the original version of the Hawks. And that has been done, and as we all know, there is nobody today who is suggesting that the Hawks are the answer to the problems that we have with serious corruption in South Africa. In fact, the president in 2024 signed into law legislation creating a new body, the Investigating Directorate Against Corruption, within the National Prosecuting Authority. That is a very clear indication that the Hawks are not regarded as being a body that deals with corruption successfully. Of course, the Hawks deal with other priority crimes rather well, but when it comes to corruption, it is a very complex and difficult area of law enforcement, which has simply not been successfully tackled by the Hawks. So the investigating directorate against corruption is actually a very poor carbon copy of the Scorpions, or the Directorate of Special Operations, which we had in South Africa until 2009, when it was summarily closed down after Jacob Zuma became the president. The acting Minister of Police has, before this very ad hoc committee, admitted that it was a mistake to close down the Scorpions back then, and creating a poor carbon copy of the Scorpions in the form of IDAC is not helpful, and it is not constitutionally compliant either, because what the court has demanded is a single body outside executive control. IDAC is not a single body, it's a sub-body of the National Prosecuting Authority, and it certainly isn't outside executive control. The policies of the National Prosecuting Authority are have to enjoy the concurrence of the Minister of Justice, and the Minister of Justice has final responsibility over the National Prosecuting Authority,
right,
and also has the benefit of a Director General of Justice, who is the accounting officer of the whole of the NPA. So it has no control over its money, over its funding. So all of those features, the current multi-agency approach ought to be replaced by a single agency approach when it comes to tackling corruption. And the idea of having the corruption busters in the police or the NPA simply doesn't work because of that executive control, which the court has said should end. That is really the business of this ad hoc committee. It needs to find a way to do so. One of the members of the ad hoc committee is the Honorable Glynis Breitenbach, and she has proposed an anti-corruption commission under Chapter 9. But that isn't necessarily the only way that the judgment can be given effect to, but it should be given effect to if there is any respect for the courts and the rule of law. Final judgments of the highest court are binding on the parties to which they apply, and the Cabinet and Parliament are indeed bound by the ruling that says a body outside executive control is required to deal with corruption effectively in South Africa. If we don't get such a body, we're going to have an ongoing problem with corruption, as the evidence tumbling out both in the Nhlanhla Commission and the ad hoc commission very clearly demonstrates.
So Advocate, I mean, the emphasis is on that body being outside of executive control. And correct me if I'm wrong, I remember you saying yesterday at the Parliamentary Ad Hoc Committee that you have more faith in the 7th administration to see this through more than any other administration beforehand. And it seemed as though from the questions that you were getting from the parliamentary ad hoc members that they didn't quite understand how this would work, especially when it comes to outside of executive control. Maybe if you could explain it just in layman's terms, in terms of how this would then operate.
Yes, the point that I made was that I have more faith in the 7th Parliament than in the 6th, 5th, 4th, all preceding parliaments, as a matter of course. The Parliament of 2024, our current 7th Parliament, actually for the first time in the history of South Africa, rejected the budget proposals of the Minister of Finance. That has never happened before, and it has happened now because our multi-party constitutional democracy under the rule of law is beginning to manifest itself in practice and in real terms. Now, the difficulty with understanding how a body outside executive control would operate in the context of anti-corruption work is actually not a huge problem at all. If you think about the existing Chapter 9 institutions, all of them are outside executive control. All of them report to one or other portfolio committee of Parliament that has to deal with the topics that they have been designed to address. So, for example, the Public Protector reports to the Justice Portfolio Committee, and the Auditor General to SCOPA, and so on. All of them have their reporting lines, and the executive has nothing to do with the work of Chapter 9 institutions. And in fact, in the Glenister judgment, there's a bit of a hint. Judges don't make laws, they indicate what laws are constitutional and what are not. But in the judgment itself, there is a hint that Chapter 9 would be an embracing and welcoming home for this new body that is envisaged in terms that bind government for dealing with serious corruption and organized crime in South Africa. So Glenis-Breitenbach's bills are currently pending before Parliament. And if they are not accepted for one reason or another, then it will be necessary for civil society to go back to the court and say, excuse me, judges, you said that you wanted a body outside executive control to deal with corruption. It hasn't happened. The Breitenbach bills were an attempt to make it happen. They have failed. A two-thirds majority is required, so it's going to take some work to get that majority in Parliament. And IDAC is not a body outside executive control.
Right.
It is actually a part of the NPA, which is very much under executive control.
Oh.
So that is really what we debated for much longer than I expected. I was invited to be there
for just
from
an
11
hour.
to 12, and I was there
for
until
more than 5. Well, Advocate,
Yeah.
thank you so much for your time and just for those contributions. Certainly is one that the Parliamentary Ad Hoc Committee needs to take into consideration, especially for that body that would work outside of executive control. Thank you so much for joining us this evening. That was Advocate Paul Hoffman, who is the Executive Director of Accountability Now.